Okay, Chair lays out Senate Bill 14 and recognizes Senator King to explain the bill.
Thank you, and thanks everybody for their patience. Everybody needs a break every now and then. We've heard a lot about DOGE lately at the federal level, but really Texas has done a very good job of being as efficient as possible with our resources. Yet while Texas is widely considered a top state to start and grow a business, there are improvements that can be made to the state's regulatory and compliance processes that will ensure Texas maintains its economic stature. The Texas Government Code, Chapter 2001, requires state agencies to review existing regulations every 4 years from the date of implementation to determine their continued need and effectiveness. Upon review, each agency must decide whether to readopt, amend, or repeal the rule following the same required procedures for their initial adoption. That's an obvious challenge for all agencies, particularly if you're the agency that put it in place, which you obviously are. Sometimes it's hard to go back and acknowledge that something hasn't worked quite right. Related to this, the U.S. Supreme Court recently overturned the long-standing Chevron doctrine, which directed federal courts to give special consideration or deference to government agency interpretations of statutes and rules above those by private litigants who are challenging interpretations. While the Chevron doctrine never directly applied to Texas state courts, nonetheless, the Texas Supreme Court referred to the Chevron doctrine when it provided a similar but less prescriptive standard that directed state courts to give reasonable consideration to state agency interpretations that are not in conflict with state law. So why do we need this bill? Well, although the legislature directs agencies to review their rules every 4 years to determine if the rules should be readopted, amended, or repealed, the reviews are performed entirely, as I mentioned, by the very same state agencies that adopted the rules initially and that are also responsible for implementing and enforcing those rules. This leaves us with Texas having the 5th highest number of regulations in the country. Let me say that again. Texas has the 5th highest number of regulations in the nation, with more than 274,000 restrictive words contained in over 44,000 adopted rules in the Texas Administrative Code. The number and complexity of regulations makes it difficult, expensive, and time-consuming for individuals and businesses to determine what, if any, regulations apply to their business plans or activities. The state does not provide a simple, one-stop website through which Texans may review all regulations that apply to a particular business. Further, the Texas Government Code in Chapter 2001 directs state agencies to perform and provide notice of the cost, benefit, and impact analysis for each proposed and readopted rule. Unlike other rulemaking requirements, failure to perform a cost, benefit, or impact analysis may not be used to invalidate a rule. Finally, the repeal of the Chevron doctrine has raised questions as to the guidance for state courts about whether any special consideration should be given to state agency interpretation of laws or rules. As I mentioned, now that the Chevron doctrine has been overturned, that standard for the judicial review of state agency interpretation of laws has not been clarified and leaves us in a situation of confusion before businesses and the courts. So what solutions does SB14 offer? Senate Bill 14 would create a new Regulatory Efficiency Office within the governor's office to provide needed assistance and direction in identifying rules that are no longer necessary or effective, and in proposing amendments to rules to modernize them, lessen their restrictiveness, or reduce their costs. To assist the office, the bill would establish a regulatory efficiency advisory panel with members who have specialized knowledge and expertise in regulatory compliance matters. In addition, the regulatory office would assist in providing improved cost, benefit, and impact analysis, giving the public more and better information about state rules. The bill would also create a new user-friendly web portal to give individuals and business owners the ability to search for rules and requirements applicable to their specific business activities and plans by typing in simple descriptive information, simply one-stop research. The bill would also add failure to produce a cost, benefit, and impact analysis to the list of items for which a rule may be challenged and invalidated. To avoid any confusion in state courts now that the Chevron doctrine has been overturned, the bill would also codify the standard for judicial review of state agency interpretations of law or rules to provide that state courts are not required to give any special consideration or deference to state agency interpretation of law or rules. And, Mr. Chairman, I would welcome a discussion about this bill as laid out. I will mention that late last night we received a fiscal impact statement that was quite surprising. We have had preliminary discussions, quick discussions with the governor's office, and we'll be discussing with LBB. We think there's some confusion over that issue, and I think everybody's on the same page, and I think we'll be trying to get that worked out shortly before we would ever come to the floor with the bill.
Thank you, Senator King. Members, are there any questions for Senator King?
No, but I think I'd like to make a few comments at this time unless Bill Author or you, Mr. Chairman, prefer we wait until after witnesses.
You know, if you wouldn't mind, why don't we do that and hold it before our close? If we could do that, if you don't mind, because we may be able to, you may be able to work some of that into the testimony, if that's all right with the chairman. I would ask that, Chairman, when you call witnesses, that you might start with Rod Borderland with the Coalition for Regulatory Reform. I think he can answer a lot of detailed questions about the state of regulation in Texas. He might be somebody good to start with. But I'm happy to answer any questions.
Sure. Senator Alvarado.
Thank you, Mr. Chair. Is there a resource witness or witnesses?
Yes, there are evidently a few resource witnesses.
Okay.
I think we've got I think there's at least 5 witnesses that were invited that I think on a panel could help answer your questions.
And
Go ahead, Senator.
do we have any agency heads, current or former? Anybody from any agency to testify about this?
Information Resources Association of Business.
No, the governor's office is not here.
This office is going to be in their office, right?
That is the intent of the legislation.
Okay.
Okay. Well, with that, let's open up public testimony, and the chair calls Rod Borderland. If you will, Mr. Borderland, please state your name for the record.
Go ahead.
Okay, and chair also calls up Scott Norman Jr. Which one?
Heidi Langdon.
Heidi Langdon and
Judge Shepard.
Judge Shepard, please. If you guys would come up, take a seat. Mr. Borderland, if you would. Yeah, you can start from anywhere. Yeah.
Sure.
So state your name and who you represent and your testimony, whether you're on, for, or against.
Yes, Mr. Chairman, thank you very much. Mr. Chairman, members, I'm Rod Bordelon. I'm representing the Coalition for Regulatory Efficiency and Reform. I'm an attorney here in Austin, Texas. I have a long history with regulatory issues and regulatory matters, practicing inside and outside government. And Senator, I was head of two different agencies, taking them through sunset on two different occasions, implementing a number of reforms and rulemaking, and responsible for reviews of those rules appointed by Governor Perry and Governor Bush before that, so I go back a ways. I did want to just touch on Chairman King, I do appreciate you laying out the bill, and I think everything you've said already speaks to what we believe this bill is set to accomplish. As you mentioned, Texas is, I think, undoubtedly the strongest economic engine in the nation. There is just that lagging issue on the fact that we have an inordinate number of regulations, the 274,000 as measured by the Mercatus Center at George Mason University, which is the only one that does an objective count of regulatory restrictions in the administrative codes, and we do indeed rank 5 in that category. Most of those, of course, have accumulated over many, many years, and as you stated, Mr. Chairman, there are a number of tools that you all have implemented as legislature to try to continue to mitigate the increase in those regulations and indeed require either the readoption or amendment or repeal of those that are unnecessary and inefficient. Nonetheless, we still have a very high number of regulations. We're not suggesting that all of those regulations are bad. Indeed, as I mentioned, I've actually been responsible for implementing a number of them myself. But the regulatory review process, the 4-year regulatory review process within the agencies, is an important tool. Does result in some changes from time to time, but typically, and I think there's been some testimony in other occasions from agency heads that say, you know, they're busy implementing and enforcing the rules that are in and the statutes that are on the books. To ask them to go through and provide this kind of analysis to see if there's a better way in which we can regulate is really up to the task of the legislature. But in terms of digging into the rules that are on the books, that should be done or could be done in that 4-year review process if the agencies were giving some assistance and support from outside their agency. And that's why this bill speaks to adding the governor's office and efficiency division to actually provide that assistance. Not too unlike the Division of Regulatory Compliance, but that is a very limited scope division of the governor's office that looks at just a number of small licensing agencies. So that and the other provisions that you mentioned, Mr. Chairman, we do in fact support Senate Bill 14.
Thank you, Mr. Bordelon. And just as review, please limit your remarks to 3 minutes. Judge Shepard.
Yes, sir. That is I. Hello, Chairman King and esteemed members of this committee. My name is Judge Shepard, and I am a policy analyst for the Texas Public Policy Foundation. I want to reiterate for the record that judge is my name. That is not a title. However, and I am here to testify in favor of Senate Bill 14, the Regulatory and Efficiency Reform Act. This bill is about cutting red tape, increasing transparency, and ensuring that government regulations work for the people and not against them. As we mentioned earlier, you've heard that 274,000 restrictive regulations across 44,000 adopted rules. However, that's an overwhelming maze for businesses to try to navigate compliance. SB14 changes this by establishing a new Regulatory Efficiency Office within the Governor's Office, as well as this office will provide much-needed oversight, helping agencies evaluate rules and conduct the thorough cost-benefit analysis like Mr. Rod here just mentioned. However, excessive, outdated, and unnecessary regulations stifle economic growth. As mentioned earlier from the Mercatus report at George Mason University, it is predicted that a modest 10% reduction in regulations would expand Texas' economy by $52 billion about up to 2037. SB14 will create a user-friendly online portal where business owners and individuals can easily find regulations that apply to them. There's no more endless searching, and just giving you clear, accessible information at your fingertips, as well as as well as making sure that all laws are written in plain language. I believe that it's in the best interest of all Texans that you don't have to have a law degree to understand the law or regulations, and as well as this would provide direct notice of rule reviews and actively solicit input on the cost and impact of regulations. That means Texans and business people alike will have information and have a real voice in shaping the rules that affect their daily lives. Further, SB14 also adds that provision that if an agency fails to conduct the required cost-benefit analysis, the rule can be invalidated, ensuring accountability at every level. In June 2024, as mentioned earlier, the Supreme Court overturned the Chevron doctrine, reaffirming that courts should not automatically defer to government agencies' interpretations of the law. This bill aligns with the decision ensuring that Texas courts are not required to give undue deference to agency interpretations, ensuring fairness, balance, and regulatory power is exercised responsibly. Ladies and gentlemen, this bill is not about eliminating necessary regulations. It's about making them work better, and it's about fostering economic growth for the people of Texas. And I strongly support this bill. And thank you all for your time and allowing me to come before you today.
Thank you, Mr. Shepard. Scott Norman.
Yes, thank you, Mr. Chairman. My name is Scott Norman. Senators, my name is Scott Norman. I'm the CEO of the Texas Association of Builders. Good to see all of you again. Looking forward to working with this committee going forward because a big part of economic development is making sure the advantages Texas has historically had when it comes to housing are continued and that we can address housing affordability and attainability. Here today in support of Senate Bill 14, and our national association estimates that 25% of the cost of housing is due to the regulatory burden. That's on the state, local, state, and national level. And granted, most of that burden is at the local level, city, county, where most of our members, builders, developers, remodelers are interfacing with government. And a lot of what we've talked about, and y'all have heard me talk about over the years, is trying to strike that balance between reasonable regulation and housing affordability or housing attainability. And of that 25%, about 2/3 is during the development stage, or 16% or so, and a third of that 25%, or 8 or 9%, is during the construction phase. But to be consistent, we also think there are places on state level government that we should look at the regulatory environment. Our members have to interface with a number of agencies: TCQ, TDLR, State Energy Conservation Office, Department of Insurance, TxDOT, Water Development Board, State Plumbing Board, to name a few. And having a sharper pencil looking at those regulations, understanding that some regulations are needed, but also looking, we really like the part of this bill that talks about the cost-benefit analysis, and those impact analyses to be performed. They're already required to be performed, but make sure they are. Especially, we engage many times to state the cost to housing or the cost to the housing industry and what it does to drive up that cost, and so we think that is something that is important. Prior witnesses have laid out the other portions of the bill, and we support that, but I do think the cost-benefit focus of this bill is particularly important going forward. So we support the legislation. Look forward to working with this committee on this and other issues going forward. Thank you.
Thank you, Mr. Norman. Heidi Langdon.
Good afternoon. Thank you, Mr. Chairman. My name is Heidi Langdon.
Would you pull the microphone? Yeah, thank you.
Better?
Yes.
Okay. Good afternoon. I'm Heidi Langdon. I serve as the Vendor Manager Director for the Department of Information Resources. I'm here today to act as a resource testifying on Senate Bill 14, so I'm happy to answer any questions the committee might have.
Okay, very good. Members, do you guys, anyone have questions for any of these witnesses? Senator Johnson.
Mr. Norman, I know that you've worked very hard with local governments and state governments to try to reduce the regulatory costs so that people can afford homes, and I applaud that work. Have you ever spoken with a state senator about regulatory issues?
Yes.
You ever spoken with a state representative about regulatory issues?
Yes.
Have you ever spoken with a regulator about regulatory issues?
Quite a bit.
Have you ever spoken with Lieutenant Governor's office about regulatory issues?
Yes, sir.
Have you ever spoken with the Governor's office about regulatory issues?
Absolutely.
And why do we need this office in the Governor's office?
Well, I don't think.
And I'm sorry, I don't mean talk to you in particular. Let me make a general comment. If we can have an office in the governor's office who's paying explicit attention to clearing out the underbrush of 100 years of useless regulations that are slowing things down and interfering with everything on the business side and the consumer side, I am all for it. The way this bill is drafted gives me a great deal of concern. And so I want to just discuss with each of you, and I'll probably have some comments after you leave the table, about what exactly are we doing here, and are we creating problems in the name of trying to fix problems? Now back to the question.
Thank you for that. Thank you for that question, Senator. Your answer on clearing the underbrush, I think, encapsulates why, as an association, we're for this. I will leave this to much more esteemed elected officials to determine how that is done. But having, whether it's the governor's office or somewhere else, someone that is putting a spotlight on this, especially from our perspective when it comes to housing affordability and those sorts of issues, I think that's a good thing. And if that takes, someone beating the drum and getting more attention to that, that's not necessarily a bad thing. Yes, the legislature who writes all of the laws that result in these rules ultimately are the ones that have the ultimate say on what happens at these agencies. Y'all create the agencies, y'all fund the agencies, and y'all write the laws that end up being adopted and create these, whatever the number was, 277,000 rules or whatever that exist.
Well, we don't write rules.
No, you don't. But the rules
rules.
theoretically are written in response to the laws that y'all pass. And I think, just like the portion of the bill dealing with the elimination of Chevron deference, they should, and it doesn't happen as much in Texas, I don't think, but it does occasionally where agencies go way beyond what was ever discussed in these committee hearings and on the floor of the House and the Senate during the legislative process. And I think that's where, as a regulated businesses operating in this state, who very actively participate in the legislative process, it ought to be the intent of the legislature that's being interpreted. So that's a portion of this bill that we think is important.
And those rules and regulations are created by agencies led by whom?
Mainly by folks appointed by the governor.
And the governor can fire them or hire them and give them instructions, right?
Well, I don't know if he can technically fire them, but he certainly can hire them or get them appointed.
And if there's underbrush here, and believe me, I'm still in favor in general of a limited version of this concept, but we have the Legislative Budget Board, we have the State Auditor's Office, we have the Sunset Advisory Commission, and Mr. Bordelon, I think you'll probably talk to us in just a second about whether or not and to what extent this invades the proper purview of the Sunset Commission. I mean, we've got a lot of systems in place in this state to ensure that we are the most efficient state in the U.S. As for there being, I forgot how many thousands of regulations there are. It sounds like a lot. Again, we could clear some out. We also we have the second largest economy in the U.S. and probably the most diverse economy in the country. So it would make sense that we might have more regulations than other states. So all of a sudden, we want to create this new office when we've had all these other mechanisms. Are those inefficient? Should we get rid of the Sunset Commission? Should we get rid of the Auditor's Office and the Legislative Budget Board or curtail their responsibilities? Or are we layering on another bureaucratic institution in order to make sure our bureaucratic institutions are properly functioning?
Do you want me to defer to?
The whole panel can open up to that one because it's a real concern, right? If we're going to be sincere about being a conservative government that wants to be efficient.
I think, Senator, your concerns are spot on. This is why we're actually not creating a new review process. This is to actually continue on with the existing 4-year review that the agencies are engaged in now. So it's not adding a duplicative process. It's not adding any additional authority for the governor and the governor's staff to actually change any of those rules on their own. There's no unilateral authority to amend, adopt, or repeal rules. All of that continues to remain within those agencies that have adopted those rules in the first place, and which you have directed by statute to engage in that rulemaking function. So this is just giving additional assistance in that 4-year review. I'll tell you, just having reviewed a lot of those rules myself, and then if you can look at the review process, oftentimes about the only time a rule is repealed, and there's nothing wrong with this, some of the underbrush would be simply you hadn't looked at that rule in a while, and it turns out that the statute that that authorized that rule to exist may have been repealed already or amended. If it was repealed, then that's a simple process. The agency would just post that we're repealing these rules because the underlying statutory authority is no longer there. That's great. That's housekeeping. Sometimes you've amended the statute, and they may have taken some issue with amending the rule to accomplish that amendment in the statute, but they didn't really go far enough. The 4-year review helps them take a look at that. The problem is, as I mentioned, most agencies, and mine included when I was running agencies, were really pretty bogged down in just the day-to-day implementation and enforcing of the laws. So you're looking at that real surface analysis. This isn't by way of criticism. It's just they do the job that they can do. If you can provide additional assistance, I think we could really go through and look at the underbrush and find a few other instances where, if not entirely repeal a rule, you could maybe make some additional amendments to make that rule less restrictive. Some of the standards y'all have imposed in law or in the government code relative to the legislative branch speak to this same thing. Look at the intent should always be look at the least restrictive way that you can accomplish whatever you're trying to accomplish. If there's a harm or a risk of harm to the public's health and safety or whatever that may be that's out there that was enticed y'all to impose a statute and then cede that authority to a regulatory agency to implement, we should always look to see if that risk is still there and if that rule is actually being effective in doing that. You mentioned Sunset. They do a great job of reviewing these things. They come up with a lot of recommendations. I review those all the time. I will tell you, and I've mentioned I've engaged with Sunset staff as a regulator. So they had a terrific, exhaustive process. That one's pretty spread out, of course, as you know, 12 15 years, sometimes longer. So this is just saying, look, we already have this 4-year review of these rules, but you're throwing all that on the agency, and they, in my view, they need a little assistance. That's all we're doing.
So thank you for that, and it's somewhat reassuring. And I see my colleague Senator Shortner has his light on, and I want to let him go with one more comment, and then I actually do want to go through individual parts of the bill. Last comment before I shut up for a moment, and that is we are in an era right now, in the small sense of the word era, of precedented, not unprecedented, of precedented consolidation of commercial power. The last time we've seen this kind of market power consolidation was a Gilded Age. And what I want to be sure is if we create an office within the governor's office, staffed by business, that has the interest of making it easier for business to operate in this state, which could be beneficial to everybody, that it doesn't merely become a tool by which those with market power can further consolidate their market power. And I see in here a specific provision that says there's going to be a forum to advise the panel, to advise the office in writing a report, and that the panel can help write the report. And that sounds an awful lot like saying, hey, come on in and write your own rules. And that's dangerous. Would you agree?
Well, no, I don't agree that that's the way I read it, and certainly not the intent of what's in this bill, in my view. Those procedures, and whether it's the forum or the panel that provides this, the panel and the forum are just a way to engage the public and regulated markets to provide assistance to the efficiency office. They're not absolutely necessary, but they would likely have some input to provide anyway. And as you say, they have an opportunity to provide that input directly to the regulators. But as long as this efficiency office would be in existence to assist those regulators in those 4-year reviews, why not allow the public to actually interact with the efficiency office as well?
And you don't want any of this to be done at the expense of protections to consumers or causing markets to become distorted in favor of certain players.
No, I certainly do not believe that, and I would lean heavily on the legislative process and also the regulators, because as I mentioned, this is not taking any authority away from the regulatory agencies. It's just providing them assistance. The regulatory agency is still primarily and uniquely responsible for those regulations. They answer to you with respect to whether or not they've implemented the statute according to your wishes, and they're responsible to the executive branch and to the public in general about whether or not they've followed the law and the Constitution of the state. And so whether some efficiency office or panel comes in and makes recommendations, it's up to that regulator to say, okay, that might sound like a great idea, but it's not in keeping with the law or the Constitution. We can't do it that way. There might be a dialogue you could continue to engage in to see if there's a way to reduce the restrictiveness and the cost of those regulations, but the decision making would always be with the regulator. Just like the decision making, there's some other provisions in this bill that talk about the efficiency office could make recommendations to the legislature for changing statute. It's your final decision as to whether or not that statute should be changed, not the efficiency office.
And would the legislature get a copy of the report of this
Yes.
board?
Yes.
Because the statute doesn't say so. It says that they'll
I
give
believe
it to
it
the
says
governor
to the
and the
LGB
legislative budget
or-
board.
Right. It's not to us.
Yeah.
It would not be to
So you
us.
wouldn't mind it being rewritten to go to the legislature as well?
I think that would be fine. Yeah,
Probably
I
ought to
think
be
that-
made public too, right?
Oh, absolutely. But if that needed to be spelled out, I certainly wouldn't have any problem with doing that. I think maybe we were thinking of the report. What I was thinking you were referring to was the biennial report that they would be submitting, and that would go to you. But you're talking about every recommendation on rules to go to the legislature.
I was referring
We could do
specifically
that,
to the
but that-
report. We can talk about the rules
Yeah.
later, but I mean the report.
You
and,
would just need to, how much do you want to be inundated with the details of it? But
We
I
like
would
to know
certainly
what's
have no
going on.
problem with that,
Yeah.
if that, yeah.
I appreciate you. I've been talking for a while. I'm going to cede to Senator Schwertner.
Well, thank you, Senator Johnson. Senator Alvarado?
Thank you, Mr. Chairman. Senator Johnson brought up a good point earlier about many of you, with the exception of our resource witness, having hired guns that come and talk to us on a regular basis, right, about whatever issue you're advocating for. So I'm just trying to get my head around this. Tell me, what would this office do that Sunset doesn't do, that the agencies don't do, and that the legislature doesn't do?
Well, again, Senator, fair question. It's not adding a new procedure. It's just assisting the agencies in the existing procedure of reviewing their rules every
Okay,
4
stop right there. Why do you think our agencies need assisting?
Because again, we mentioned the sheer volume of rules that are in existence, and every one of those rules has many sections and many pages, each with many regulations. So that's where we get to the high number of 274,000 regulations out there. So the agency does a great job and can continue to do a great job of doing the initial analysis to just determine, is the statute still in place? Is that rule still necessary to implement that statute? If that's the only analysis you want to continue to be done, the agency can continue to function doing that. This would add additional analysis, because if you look at the government code, what is contemplated, what you specify in there is for the agency to have an opportunity to, as Senator Johnson was mentioning, essentially cut through some of the weeds that are underneath or the underbrush to see there might need to still be some of those regulations, but when you open those up, there might be 14 sections and 2 or 3 of them are not necessary, or you can reword some of those to be less costly or less restrictive. So the statute is still in place, perhaps. The rule can still be in place, but there's a way to do this less costly and more efficiently, and that's something that y'all have actually put.
Well, let's talk about less costly, because the fiscal note on this is not less costly. Okay, so let's see where we are so far. We've got how we're growing government. Okay, some people run around this building talking about we need less government. Okay, so we've got a new office, we've got a panel, we've got a $15 million fiscal note, and we are adding 35 new FTEs to carry out this task. Mr. Chairman, I just, there's so many unanswered questions with this, and I would hope that we can slow this down a bit, because I think some of these things need to be fleshed out. You mentioned in your testimony that there's much needed oversight. When you say that, I feel like you're saying that you have no confidence in the legislature or the agencies, by the way, which are headed up by people that the governor appoints. So are you saying there's a lack of confidence?
No. If I implied that, that's not correct. I don't. As I mentioned, I was a former regulator and appointee myself. I have great confidence in the regulators in this state and the agency heads. I do think they could use some assistance in the 4-year reviews of these regulations. So again, we're not adding to, back to the fiscal note, I think that certainly surprised us as well. It's certainly not the intent or expectation of my organization that the government should spend anywhere near that amount or have anywhere near that number of FTEs. Whatever needs to be fixed, we're happy to work with this committee and any other parties to see if we can't.
And many brag about this state, and many of us do, that we have less regulation, and that's why businesses move here. So this is contradicting that. Let me just, and I don't know who the appropriate person to ask about this, but if this new office determines that a rule is unnecessary or ineffective, but the agency insists on keeping it, what is the process for resolving the dispute?
There would be no dispute. It's the agency's final determination, and they simply keep the rule as is or make other amendments on their own based on those recommendations. So if the efficiency office comes back and identifies 2 or 3 rules that are in place or regulations within those rules that should be repealed or amended, that regulatory agency can accept those, can agree with those, or and by the way, even if they did, it's not automatic. They would still have to go through the rulemaking process to amend those rules or repeal them. So you would still provide notice, post notice in the register, just like the rulemaking procedure. So it doesn't set up a new procedure for repealing or amending rules. You would still go through the regular rulemaking process. This is just providing assistance to those agencies and helping them identify.
So could an agency's refusal to implement feedback from the governor's office lead to any disciplinary action? Mr. Chairman shaking his head no. Okay.
There's certainly none added in this bill.
You seem to know a lot about this. Were you part of the formation of this?
My coalition has certainly been engaged in.
Did you bring this to the legislature? Is this?
We have.
Was this your idea?
We have offered many of these ideas. Yes.
Okay. One last question. How does it ensure that existing public participation rights, say, for example, like TCEQ, there are a lot of regulations in there that allow for public input. For example, like concrete batch plans in public hearings. Will there be explicit protections for public engagement processes in rule reviews conducted by this new office of 35 FTEs?
So the Open Meetings and Open Records Act and the APA that are all contained in the government code cannot be at all amended or repealed by any recommendation from the efficiency office. Now, they can make recommendations back to the legislature to amend some of those, and if they said, hey, we have far too many advisory committees in certain agencies, that gets discussed through sunset or whatever. That type of thing, because that's in the law, would be up to the legislature. So all the required notices that are in statute, and if there are any specific ones in different agency statutes, it would be the same thing. Those agencies would not be able to change those because those are statutory.
Okay, I'm going to stop here, but thank you. Looks like you've spent a lot of time drafting this. Thank you.
Again, I would just say, Senator, I share some of your concerns to make sure that we get the word out about what, at least how I read what this bill does, and if there's any clarification that needs to be made, and certainly with respect to adjusting that fiscal note, because I do think that's a bit beyond what was expected.
I'm just trying to figure out what's broken here. You know the old saying, if it ain't broke, don't fix it. And from what I've heard, it feels like maybe some just don't have confidence in the legislature, the agencies, or sunset zone?
To reiterate, from my perspective and the coalition that I represent, it's not a matter of lacking confidence in the executive branch agencies. We have full confidence, and I think, as Mr. Norman mentioned, many of our members interact with those regulators on a regular basis, and do have full confidence and expect that they will follow the law.
Thank you, Senator Alvarado. Senator Swart, you have a few questions?
I do. Thank you, Mr. Chairman. Mr. Bordelon, you mentioned a 4-year review process that agencies currently undergo, right?
Correct.
Self-directed review process of their rules, right?
Well, it's directed in statute, but they do their own review.
And who is that report given to, that review of their rules?
I'm sorry?
Who reviews their analysis of their rules?
Well, it's an internal process, so whatever staff the agency head directs to perform that review, usually some sort of legal staff or compliance staff within the agency will review those. There's usually generally divisions within that agency responsible for different aspects of the regulations within the authority of that agency, and they'll review their section rules and then make those recommendations to the
Director,
executive
commissioner,
leader,
or
executive
whoever it
head.
is,
That's
yeah.
correct. Yeah.
So there's already a process
Yes.
to look at rules, just like there's already a process by Sunset to look at agencies in totality. Can you hear me?
Nope, we lost you.
Yeah. Okay, there you go. Agencies in totality as to whether or not they are efficient and whether or not they should still exist.
Yes.
So we are looking at statute and agency function and rules at the department level as, the hierarchy goes all the way up, obviously, to the governor. So in some ways, the governor could crack the whip on executive directors and commissions and say, hey, y'all need to get rid of 10% of your rules in your next evaluation and do your job as far as running the agency. That's one way of handling it, right? I guess another way would be kind of like what happened at the federal government with DOJ, an outside extra-jurisdictional evaluation of rules and spending. And then I guess the third way would be, as envisioned in this bill, which would be establishment of a office, is what is being called, within the office of the governor, called the Texas Regulatory Efficiency Office, not to be confused with the Regulatory Compliance Division within the office of the governor. Right. So, and the division I know came under the University, or the North Carolina Supreme Court decision regarding too much monopoly power at the rulemaking authority and oversight, and so they have kind of a different focus, but they still, my understanding is, look at all rules, and even though they have more of a limited initial thought or scope. And the concern at that time 4 years ago was that we were investing in the governor's office too much rulemaking authority, which we as a legislature should be actually done at the agency level. And so this whole discussion really, I think, boils down to how a rule is made, who reviews them, how are they implemented, with what veracity and what force. And so a change in the rules, even though you're saying it in this bill, is only a suggestion, recommendation, I believe.
That's correct.
The powers that be, the flow of power goes from the top down when it comes to rulemaking. And so you have a centralized regulatory efficiency office recommending changes in rules. If I was an executive director or a commission member, I'd take them pretty seriously as to whether or not I should make that rule change, right? Would you agree with that?
Well, I would agree that they should take them seriously.
In other words, I would take them so seriously I'd do it 100% of the time.
No,
How about that?
I think they. I could speak to my own personal view when I was agency head, and I took my.
Which agency did you run? I'm sorry.
I was Commissioner of Workers' Compensation. And
Okay,
I was
workers'
Public
comp.
Insurance.
Which was rolled into something else eventually, right?
Division, Department of Insurance.
Yeah. Were you head at that time?
I was head of the Division of Workers' Compensation.
When it was rolled into
No, but I was appointed after that.
Okay.
But at a time of great reform when when we were.
I remember some of that reform.
Yeah.
So again, going back to my question,
So every agency
if you were agency head and you had someone tell you on high that these are some rules we think maybe should be changed, and you didn't agree with them, what would you do?
I would take their recommendation very seriously if the governor's office
Seriously.
were to call me, and we would have those discussions from time to time, not usually at that level. I never had the governor's office reach out and say, hey, I want you to repeal these rules or, amend these rules. They would. So there's policy staff in the governor's office now, and they could look at any activities within an agency
And so
ask questions.
that goes to a different item, but it's similar. People in the Capitol, policy people, they might have run offices, they might have been in the industry, but they're not in the day-to-day trenches of looking at rules, reforming agencies, implementing laws. It's an interesting concept of who should review what, when. You can make just the same case, and maybe you even thought of it, putting this Texas Regulatory Efficiency Office, which looks at rules, and combining it with Sunset, which looks at laws and agencies in totality and efficiency, into one entity that looks at both. But of course, that wouldn't be centralized control. That would be legislative control, right? Because who controls the Sunset process?
There are some. I don't think we can speak to other statutes or
Let me
bills, but
inform
there
you.
are
The
some other
Sunset process is run by the legislature, right?
That's correct, and there are some other recommendations to looking at the sunset process as well.
Yes.
But-
But again, rules and laws are often, obviously, as you were saying, Scott, the laws mandate the rules, which are instituted by the divisions or the departments. And I still have yet to figure out what the difference between department and agency is. I think they're the same. But, speaking of that, what's the difference between a division and an office? Because we have both now in the governor's office if we were to implement this, right? Is there a difference?
I think
Is the
I don't
office a department?
Yeah, I don't see a great difference. I think this is just some of the ledge council drafting. I'm not sure why office was used rather than.
So we have an office, and one's not more powerful than the other, right? Division, office. We have two offices, actually. Two offices and a division.
Whatever authority they may or may not have would be spelled out in the statute, and I don't see any great authority to actually unilaterally do anything.
So
other
if
than
you wanted a true outside review, would you put it in the hands of the person that has the office that has ultimate authority over that entity, all the divisions, or would you put it as an outside entity with like the Sunset? Sunset
Well, again, I'm a fan of the
independent in the
sunset.
sense that we're not implementing the rules or making the rules, as Scott so ably pointed out.
I think it's a fair point, and I am a fan of the sunset process, and I do think it's worthwhile to go through that process, even if ultimately there's not too many agencies that are completely abolished. There hasn't been one in a long
They shouldn't be
time.
hand in hand. You don't think there's any benefit of putting the rules and the agencies together when they go through review?
Well, you could, but again, the rule review. This is why the reason we were looking at the concept of, and I think the bill speaks to why you would put it in the governor's office, is because that's in the executive branch that's actually doing the 4-year reviews. Sunset.
Wait. They're not doing, the governor's office is not doing the 4 years review. The
Well, they would be
agencies are.
no, but they would be in this bill. They would be assisting the agencies in that review process,
Assisting the agency.
supporting.
independent or not?
assisting- Yes.
Report.
Are they independent?
No.
They're not doing their own independent work. They're helping the agencies in the 4-year review.
That's correct, and in that because that's what's spoken to in the bill, they would actually also be authorized to make actual recommendations on that as well.
Why would they have any different recommendations than the actual recommendations of the agency if they're helping write the report?
Again, I think what we're speaking to is when the reviews are happening, the agencies may be looking at one thing, and if you have somebody outside external to that agency, they may have some other expertise and analysis that could come in and say, hey, I think we could be doing this in a better, more efficient way. How about this? It would still be up to, back to your earlier point, even if that's a recommendation from the office.
The office, not the division.
The office, not division. That agency head is sworn. I was sworn under oath to uphold the law, and I made the decisions. And whether it was the governor himself or someone else, or even a member of the legislature, if that was not in keeping with the law, I couldn't do it. So the ultimate decision maker has to be that agency, that regulator, that agency head that took that oath. because they're the ones that, if there's a challenge of that rule, no matter how it was amended, if there's a challenge of that rule, it's the regulator who gets sued and has to.
And you
defend
don't
that.
think it's usurping that regulator's statutory authority and direction and law and oath by having a whole other group of people helping write those rules for the division they oversee?
No, I don't
Department of
think so at all. Again, if providing recommendations from outside the agency, they get those all the time.
Even from the boss's office? Okay. Thank you very much.
Thank you, Senator Schwartner. Senator Johnson, you have some additional questions?
I do.
Or
I do.
comments?
And as I understand it, we're going to be voting this out today, and if it's going to be worked on, it's going to be worked on between now and the time it gets to the floor. So I think it's important to go through the bill and highlight some things that I think need attention. I'm going to highlight things, and I invite anybody who's testifying to have comments on it. They may not be directly in the form of questions, but it is an open invitation. Most of them will be in the form of questions. So let's just start with page 1, line 2, right after the words "a bill to be entitled an act." It's the relating to clause, reforming the procedure by which state agencies adopt rules, etc. I don't see a lot in this bill that pertains to procedure at all. Where in here are we talking about the procedure by which state agencies adopt rules?
I think elsewhere in the statute, there's some provisions where the efficiency office could make recommendations to the actual procedures. Now, again, statute still has to be followed unless they make a recommendation to the legislature.
But procedures by which they adopt rules, we have public hearings, we have solicitations for written comments, we have periods of publication. What in here talks about the procedures by which they adopt rules?
Senator, that may be referencing to the cost-benefit analysis being a part of the rulemaking adoption.
And so would every other page not be part related to this relating to clause?
Would every other page be related?
Well, I mean, we had all sorts of stuff in here. Again, we've talked. I'm in favor of some of this stuff. I just don't know how it's referenced in the relating to clause. I think maybe there's a problem there. All the things about having goals and what to eliminate, reduce training hours, eliminating fees. What does that have to do with the procedure of adopting rules?
Well, the fees would be adopted in a rule, and so a lot of those are actually rulemaking.
That's not process. That's substance.
Sure, but so there are processes that you'd have to follow what's in the statute, but there's sometimes some informal processes that are not established in the statute. I know when we were engaged in a number of the reforms, we were talking about very complex rulemaking. A lot of the agencies, whether they're specified in the rule or not, would engage in all kinds of informal back and forth with the public and regulated entities to try to hash out the best way to draft the rules and whether or not existing rules should be amended. So if there's a way to utilize more of that to streamline or get to the ultimate answer of the best rule, that could be something that they would take a look at.
Could be. I'm going to just highlight these things and for people to think about between now and the time it goes to the floor, if it goes to the floor. Page 2, a lot of good goals. Page 3, the word goal comes up. Page 3, line 7. The purpose is to establish a goal for each state agency to reduce rules or other regulatory requirements. Now, this goal is going to come up later on to see if they've met their goals. Senator Alvarado was making the point that this whole thing kind of has a presumption that these agencies are just driving people nuts. And I know we don't want to overregulate things. In fact, we have businesses flocking to the state of Texas, against Senator Alvarado's point. They love doing business here, and yet it sounds like there's a crisis. So if we're going to establish goals to reduce rules, what does that goal look like? Is it a number? Because I remember you used a number. You said maybe the office, this is an office, I guess, you said maybe they would recommend changes to 2 or 3 rules. So are we going to go to every agency and say, I want you to change 2 rules? Or I want you to get rid of 100 of your 600 rules? What does a goal look like?
I wouldn't speak to exactly what the goal would look like. I don't think it has to necessarily be an objective number. There could be goals about how they would address what is necessary and unnecessary. And again, there's some language in the government code with respect to even the legislature about looking at rules in a manner that is the least costly and most efficient way to implement whatever.
And that's a good goal.
Right.
I want to tell you something about my experience in this legislature. I've had a good bill die because I was too prescriptive in my bill language. It was my mistake. And something else we might want to consider as this heads to the floor. Is there too much in here? I personally think that there is. Let's give thought to some of these lines on this page below it.
Well, I'll tell you, Senator, this is legislative council language, so I'm not going to speak to every word that's listed in here.
And I wouldn't
there
hold
is
you
a
to
lot.
it, sir.
There's a lot. We would be happy to work with your office and any other member of the committee to pare that down, especially given the fiscal note, if that helps.
I appreciate the
address
good
some
faith.
of those concerns.
And so all I'm doing is, again, it's not to have arguments, but to highlight these things, because if we don't right now, who knows what happens between. So let's keep going down the page. The goal is to reduce required training hours. I mean, maybe that's a good idea, but it doesn't leap out at me as a good idea. I don't know. I just don't think that should be a stated goal. Might want to get that out of there, and maybe this office concludes that this particular agency on this particular topic needs to reduce its training hours. I don't think we need a statute that says the state of Texas trains people too well.
So I think what I would read in referring that is in analyzing the rules, whether or not the rule prescribes a certain number of education or training in order to obtain a license or an authorization to do business. Y'all look at those and Sunset, to your point, Senator Shortner, looks at those from time to time, and you have reduced those statutorily. So if they're in the statute, those have also been questioned from time to time, especially when it comes up that we require far higher number of hours of training and education than some comparable states. So when that comes up, y'all bring that up and make those adjustments statutorily. If it's in the rule and not in statute, if you gave more general authority to the regulator to decide that, it could be something that the regulator should look at.
It could be. If I were you, I'd be nervous about it. And I understand what you're talking about. There could be too much in there. Putting it in statute, it carries some weight. Reducing the amount of or eliminating fees imposed by the rules. Now we've had debates, particularly in the Sunset Commission, about appropriate fee levels, and they get set in statute. And inflation passes over 20 years, and we change the fees. I've been told often that we ought to run government like we run a business. If we're reducing and eliminating fees, we may be offsetting the revenue that these agencies have been relying upon in order to carry out the functions with which they have been charged by this legislature. Is that a good idea that we ought to put in here? Maybe. Maybe the fees are way out of line, and I know, Mr. Norman, you've probably got some opinions about fees that are out of alignment with reality, and I welcome that. But again, stuffing it into this bill makes it sound like we don't want fees. I think we absolutely do, unless we want to start imposing taxes, and no one likes that.
Well, again, coming from a perspective as a regulator in which you gave me authority as a regulator to impose some of those fees, we were always looking at whether or not the fees were only necessary and not excessive. And we did make some adjustments from time to time based on external factors and looking at what other states might have accomplished and looking what it costs to actually implement some of those.
What I hear, I won't mention particular agencies, but I've talked to some where the fees over time have gotten so low that they're really unable to finance the operations that they need to finance. So as a presumption in the statute, I just don't like the tenor of this.
We could certainly, I'm just speaking for myself, I think we could probably support either some clarification on some of these or some added clarification that this does not add, as you suggest, a presumption that those types of things should.
That would be nice language, and I think in the language concerning judicial interpretation, there is some similar language that even though it basically adopts the Loper versus Bright instead of Chevron, there's language in that provision of your bill here that says the courts may consider without delegating authority, and so maybe something along these lines would be appropriate. Likewise, with respect to creating waivers or exemptions, I mean, it's kind of a lobbyist employment act, but and I know there's times there should be waivers, but just putting it in the bill, it's out there. I'll wrap up here quickly. I wonder if all this stuff about the manual is redundant. Maybe it isn't. Regulatory reduction guide. I guess I won't beat that drum anymore. One provision altogether that I really question about is we're already creating an office that clearly is making some people nervous that it might encroach on legislative authority, it may be redundant. And then we're creating a panel to advise the office, and now we're going to have a forum to inform the panel, to advise the office that's in the governor's office that controls the agencies. This is starting to sound like too much, it seems. Finally,
I'm not responsible for all the language in this bill. Well, I'm not responsible for the language in the bill, but I'm not responsible for the specific words and some of those provisions that you're speaking to. As I read the form, it's nothing more than an opportunity to gauge input from the public without having to go through a formal hearing process, perhaps. Town hall type things when agencies go around, we would do that from time to time to gauge input from far reaches of the state to figure out what's bothering people. I could see that being a useful tool, whether that needs to be in the statute formally or not.
And since we have public hearings and written comment and legislators, I don't think so. Finally, I say finally, I probably got 3 more pages. The governor appoints 3 people, and lieutenant governor appoints 2 people, and the speaker of the House appoints 2 people. Is that right?
That's correct.
Does it make sense for the governor to be able to veto the speaker's appointments? Because that's going to give the governor effectively 5 appointments to 2 of the lieutenant governor, to in a panel that advises an office that he controls, that's going to advise agencies that he staffs. Is that concentrating a lot of power in the governor's office too much?
I know we looked at certain other similar panel type structures that were in existence in other statutes, and it's a similar type of appointment process.
I would highlight that as something the legislature considered not doing. The 2-year terms also kind of ensures that everybody on this panel is beholden to the same governor all the time. Not sure. I guess I'm okay with that. We already highlighted that the biennial report should go to the legislature, not just to the governor and the legislative budget board. And then truly finally, I do think I want to compliment the language in the final section of the bill is judicial review, whatever anyone thinks.
Would you repeat that, please?
I will repeat that. I think there was it was a very good drafting and decision to make it clear that although a court cannot effectively delegate its judicial authority to the executive branch through an agency, it can give weight and consideration to the expertise of an agency in dealing with the law that pertains to the functions that it covers. That's done well, and if we can have that kind of language somewhere else in the bill, I think it might assuage many people's concerns.
Thank you, Senator Johnson. I do have one quick question. So last session, this legislature passed a bill that basically required a third-party assessment of the foster care rules and regulations. There was almost 500 pages of those. Is that something that this group would be looking at?
Senator, I'm not familiar with that provision, but if that's in the statute, then that obviously stays. Now, that doesn't mean that the efficiency office couldn't take a look at that process and make recommendations in the statutory provisions.
Yeah, what I'm asking is, you had almost 500 pages of foster care rules and regulations, and basically we required a third party to come in and kind of audit all of that and see if there were ways that we could go in and make that less onerous for young couples to be foster parents. I'm asking, is that something that this agency or this committee would be doing?
Well,
looking at that 500 pages of rules and regulations, advising them on, hey, that this is an unnecessary.
They absolutely could, in my view. They would have the authority to take a look at those and make recommendations, but they would, again, just be recommendations.
Recommendations,
But
certainly.
That's the whole idea, yes, is to be able to look at those on these same 4-year cycles of reviewing these rules and find ways in which we can find some efficiencies and maybe make some of these rules more effective.
Very good. Thank you.
Mr. Chairman, I had a response.
Oh, I'm sorry. Yes. Yeah, please.
At the risk of probably getting myself in trouble, Senator, and I had nothing to do with the drafting of this bill. So, but to the extent that you were talking about fees, I could see in this review, and maybe the language in the proposed bill needs to be altered to reflect this, but that can cut both ways, because I know regulated industries at times have gone and said, asked for fee increases if those funds were dedicated to processing or reviewing or whatever that agency was doing. And so it wouldn't always necessarily the fees need to go down. It may need to be, they need to go up, and they need to be dedicated to that department that's reviewing whatever. And so I think that is a worthwhile thing. And if it provided a voice for the regulated industry or the public or anybody else to do that, that's not a bad thing.
Thank you for that helpful comment.
That's
Yeah. Thank you. Senator King.
Thanks, Mr. Chairman. So let me kind of back this bus up about 30 minutes if I can. So, Mr. Shepard, your initial testimony was, and you cited a report that I'm familiar with, but am I correct? What you said was that if after mentioning that, or I'd mentioned in my layout, that Texas has more rules and regulations than any other state. Now, other states have the same business as we have. They have trucking, they have water, they have airplanes, they have all these different. We have builders, but they have the same businesses. Maybe not as many, but they have the same type. But I mentioned in my layout that we have more regulations than any other state. Then you testified, citing that report, that if we reduced regulations by just 10%, it would result in what?
Yes, sir. Thank you for your question. And to go off of that, I believe it is the Mercatus Center at George Mason University put out that report, and it is showing that a modest 10% reduction in state regulations could expand Texas' economy by $52 billion by 2037, as well as I believe they also put out a 40% reduction could yield an economy more than $500 billion larger.
And if I'm correct, that's kind of been a goal of the Trump administration and other administrations in the past, where they've talked about trying to reduce. It's been recommended that you have to have a target to try to reduce one rule for every 2 rules for every one you implement, or something like this. But this was a study of saying just 10%, correct?
Yes, sir, to my knowledge.
Okay. Were there any other points in that study that really jumped out at you?
Not certain that I can give y'all at the moment.
Okay,
But,
that's fine. Thank you. And Mr. Borderland, and if I understood your initial testimony, it was that you've been a department head.
Correct.
And you had to do these 4-year reviews, whereas Sunset just meets every 12 years, but you had to do these 4-year reviews, and that your employees, even though you knew you had to do that, and you tried to do that, but everybody is caught up in the tyranny of the urgent and doing their day-to-day work, and that it was difficult for y'all to independently do that process. It was that
Correct. I mean,
frame that.
number one, it's difficult. They're again busy, engaged in implementing and enforcing those regulations in place. But also, as you point out, you have a number of staff that's actually going through those. The type of analysis that we're talking about, and sometimes is coming up with broader recommendations for that as a matter of policy. Is that something that agency should actually be engaged in those details and to that level, and can we actually back up on that? And that staff may not always feel empowered to make those kinds of recommendations or understand enough about.
Well, particularly if they're taking away their own job by removing certain regulations that they enforce. So, and I don't want to put words in your mouth, but what I took away from your testimony was that your department, when you were a department head, that you could have used the assistance of a third-party outside group to help support you in that in those 4-year review processes. Is that correct?
I think if this is structured correctly, the way you're intending, as I understand, that this actually be an assistance, I would say I could have used it, and I think most agency heads would appreciate that.
Okay. And Mr. Norman, you said something else that stood out. You said that, and you were speaking from a housing affordability standpoint. You said that what percent of the average home, what percent of the cost of an average home is from a regulation?
25.
25%. So if I build a $200,000 house, $50,000 of that home had nothing to do with bricks and mortar, with anything else. It had to do with just the regulatory environment of our requirements for building that home.
That's correct, at all levels of government.
Okay. Thank you. Thank you, Mr. Chairman.
Yeah, Senator Alvarado.
I'm just kind of lost here because you, Mr. Chairman, you pointed to this gentleman's report and you said that we have more regulations than any other state. Is that right?
Thank you for the question, Senator. No, ma'am, I would say I don't believe I said that we had more than the other state. I did list a number that we have
I think I said that.
274,000
Okay, you said
over,
that.
yes,
Okay.
ma'am, over
And I'm sure it's
44,000 adopted
correct.
rules or regulations.
Okay, because we've, everybody
Because
brags on both sides of the aisle that we have less regulations, why everybody's moving here. So I was just wondering what that report, and if you were comparing states to states, are you comparing us to New York, California? It's hard to believe that we would have more than California.
No, ma'am, I believe, I can't give you a definite, but I believe Texas is 5th overall number of regulations. However, I would love to get with your office to give you that in concrete data.
And how did you come up with 10%?
Yes, ma'am, I'm citing that off of the report from George Mason University.
Do you know how they came up with that?
No, ma'am, not at the moment. However, I would love to get with you
Oh,
and
that would
sit
be
down and go
fine.
through
Thank
that.
you. Okay, great, thanks.
Senator, I would just say I'm a little bit familiar with that report since the coalition had actually engaged the Mercatus Center on that specific finding. We were interested in finding out what the cost benefit would be for reducing regulations. It's a little difficult to do. By the way, this was done by Dr. Patrick McLaughlin. He's a PhD in economics and long researching regulations and their impact on the economy. So the 10% was just a contingent number to say, assuming that this process or any process would reduce regulations by 10%, and then he came up with that calculation of what the savings would be. And going back to the number of ranking, yes, Texas is number 5, and you're correct. So the other 4 would be California, New York, Illinois, and I believe New Jersey. So.
All right, thank you.
Yes, Senator Johnson.
And staying on that study, that was the Mercator Institute. Is
The Mercatus Institute.
Mercatus
at George
Institute, thank you.
Mason University. They do a wealth of. They have a wealth of studies on regulations and the impact of regulations, and they do a probably the most often cited comparison of the regulations from state to state.
and I'm familiar with them, and they've got good information and, of course, brilliant people. They're also libertarian in ideology, are they not?
I don't.
I think they're self-described as libertarian.
I would not be surprised, but I don't know them that well.
Right, and I don't think anyone up here is advocating for the most efficient thing we could do, which is just eliminate all rules in all agencies.
I think I started off saying that I'm assuming that at least many and hopefully most of the regulations that we have on the books are necessary in some form or other. Again, the question is how many and how restrictive they need to be.
Yeah, we have out of bounds free throw lines, 3-point lines, technical fouls in basketball for a reason, right?
Correct.
Okay.
Yeah, it's a good time to make basketball analogies, right?
Yeah, March Madness.
Okay, any further questions for these witnesses? Thank you all very much.
Thank you.
Okay, the chair calls Tanner Jones, Hasib Abdullah, Taylor Landon. And if you would, Tanner Jones, please state your name for the record and who you're with or representing and whether you're for, against, or on the bill.
Yeah, my name is Tanner Jones. Thank you, Vice Chair Sparks, Chairman King, and senators and members of the committee. I represent Cicero Action, a think tank based in Austin, Texas, but we work in several states, and I personally focus on technology policy and regulatory reform, and I am here in favor of this bill. I won't talk about many of the things already discussed. I'll try to avoid being redundant, but just a couple points I want to make. One with regards to the de novo review, judicial review amendment, and second having to do with the efficiency office. First, on the de novo review, just some additional data that may be useful. The Texas Railroad Commission case in 2011 echoes the now defunct Chevron doctrine, which was overturned this past June. Importantly, that Supreme Court decision was a statutory holding, not a constitutional holding, meaning that it's not binding on state courts. And that creates a legal limbo, which Texas is now in, that will not be clear really what the contours of Texas law are absent this statutory change until after years and years, perhaps decades of litigation. A study at the federal level found that under the Chevron standard, the reasonableness doctrine, which the Railroad Commission case echoes, agencies were winning 95% of cases that came before them in federal courts and the Supreme Court. So we can expect a similar outcome happening here in Texas, where the agencies are winning when a small business is taking them to court in Texas. If Texas implemented this change, it would become just the sixth state to require de novo review, making it a clear leader in the space and also falling into coherence with federal legal doctrine. This will have a couple important implications. One is restoring checks and balances, enabling our judges to actually exercise their judicial powers. And second is enabling a cascading precedent over time so that we understand where deference ought to be happening, where it ought not to be happening on agency legal expertise questions versus more general legal expertise questions, as opposed to a blanket reasonableness deference. But second, on the efficiency office, to clear things up, that Mercatus figure is actually just a count of words like prohibited, must not, shall not, etc. The total number of regulations in Texas is 35,380. At the Cicero Institute, we use AI and technology-based tools to inform our research. So we put together a scraper last week, a colleague and we found some fairly jarring statistics. 43% of regulations on the books in Texas are over 10 years old. 21%, or 1 in every 5 regulations on the books in Texas, is over 20 years old. 2,172 regulations on the books in force in Texas right now are over 30 years old, and 488 regulations in force in Texas are over 40 years old. There's a regulatory inertia. Every incentive is aligned to increase the regulatory burden over time. And these reflect a time long gone by of different politics, a far different business environment and public will and interest in Texas. It's time for a greater and opposite force to go in and clean some things up. I've got some more data here and be happy to answer any questions you guys might have.
Thank you. I tell you what, let's go ahead and do the panel, and then we'll do all of the questions. So, Mr. Abdullah.
Thank you, Chair. My name is Hasib Abdullah still. I am representing just myself for this particular bill. Initially, I was actually for this bill. I like to switch it back to on. I just like to speak to it. I was very excited about many parts of it, specifically the website where businesses and individuals can go in and see what rules and policies. I know this talks about rules, but even written policies sometimes have the same basis as a rule, having worked with 3 different agencies as an employee. But some of the things that I find is most of this, number one, I did not understand that this was going to be in the governor's office. I think it's almost taking power away from the legislature in some respects and the judiciary a little bit by giving the governor even more say. So, I mean, your power is very, there's reasons to check and balances. And so I think this is this is concerning for me. I didn't understand that portion either. But there's nothing in here that allows individual citizens to challenge and strike down rules and policies, like people who are a little bit more more well backed financially and such. So some of the, for example, I'll give you, if you make it a complaint to a PUC, you could at least have someone in the PUC look at your complaint. If there's some policy here or some procedure where an individual who has a startup, so they have an employee of one or two or a couple of people, would be able to go to the AG and say, look, I have a complaint about this rule. Can I somehow attack it? And they may look at it and they may not go forward. They may go forward. But something like that where an individual with no money can do it would be a lot more, I think, democratic in my opinion. Specifically, the other issues I have about this is the composition of the panel, subchapter C. Nowhere does it have individuals. I mean, I think some people should be able to apply based on merit and pick. I mean, if it's from the governor's office, that won't be based on merit. Usually that's very based on, political persuasion and such. Interestingly, it says there's, I think, a couple of members from the House of Representatives, the speaker who appoints it, the lieutenant governor, but it says in 4650103B, if the governor rejects the House of the House of Representatives speaker's list, he has to come up with a new one. So it seems a little, I don't know, just it doesn't seem fair for the House, the 150 members of the House. I think notice, in the time I have here quickly, is notice should be a lot more fair in the sense that sometimes rules affect a neighborhood, for example, or sometimes rules affect an industry or trade group. There should be not just like posting of it. You'd have to maybe knock on doors or give something where there has to be some balance where the notice is much more for the individual Texan as opposed to trade groups and stuff who are a lot more in tune to what's going on. Some of them already have access and stuff, and maybe even some had authored some of this bill. And so, yeah, I just think that the idea is very, very good. I'm for it, generally speaking, but as implied, I don't think I'm for it. Thank you for your time. Thank you for your service.
Thank you. Mr. Landon?
Mr. Chairman, members, I don't know if I was lucky to dodge the last panel or unlucky to be the last one here, but my name's Taylor Landine. I am the Executive Vice President of the Greater Houston Partnership. The partnership is the principal economic development organization in the Houston region, and we do support this bill. We felt it was important to come before you all today as a business organization, 800-plus members, to be here to support the legislation. Given the last panel, I'm going to dispense with any of my prepared comments and instead just emphasize the spirit of this legislation, I think, is directionally correct. And one of the things that I'll note is that we at the partnership interact with economic development prospects every single day as a regular part of our work. Those companies, in many cases, are looking to invest billions, in some cases, of dollars into our state. And what we hear from them consistently is that they want assurances that their investments are going to be matched by efficient and effective government. And I think that obviously there are improvements and clarifications that can be made in this legislation that all of you have brought up today. But we applaud the forward-leaning steps that are laid out here and the state's commitment to creating that environment that allows those businesses, once they're here, to thrive. And one other thing that I think is probably worth noting is our friends at the City of Houston, Mayor Whitmire, I believe this committee may have heard that they recently undertook an efficiency study that uncovered efficiencies across the city and now are working to implement many of those changes. So it's in that same spirit that you all are here today to try to make government more efficient, more responsive to the needs of residents. And so we're encouraged by the renewed commitment by the local leaders, state legislature, to abide by the principles of transparency and efficiency. And Mr. Chairman, we commend that effort and your effort on this bill, and we look forward to working with you throughout the process.
Thank you very much. Senator Alvarado.
Thank you. I was looking at the Mercatus study, and it says, what can policymakers do? It poses that question. One is regulatory budget, which the legislature can do. And then the second one is sunset. So, gentleman, I forgot your name, but in the middle there, you mentioned about your uneasiness about where this office is placed. What do you think about placing it in sunset? Because we, the legislature, give the agency their rulemaking authority. What do you think about the sunset process, about it being placed there?
Yeah, I think that would be a step in the right direction. I would have to see even the parameters of that and the rule. This is quite a bit involved. I mean, maybe I don't know if this is even possible I'm just a layman here. To even give more time for the public to take a look at this and maybe come back. But I would be for that, Senator.
Thank you.
Members, any other questions for this panel?
I would like to close it whenever the panel's.
Certainly. Thank you, gentlemen. Mr. Chairman.
Thank you. Members, I appreciate all the discussion, all the questions, and some good ideas that came out today from not just from the panel, but from the members especially. I will address just one thing real quick that the gentleman seated in the middle said. The reason that the governor has the right to overturn a speaker appointment, same thing we do on the Facilities Commission. It's a constitutional thing because the speaker is clearly a legislatively created officer, and so it's a constitutional issue if they make certain types of appointments, and that's why they do it that way. Same way we do it on for the Facilities Commission. Let me just kind of, boy, since the beginning, if Senator Johnson, I know you know this, but from the beginning of cases, there was this strain between the three branches. And then within the legislative branch, there's always been this stress between delegating authority to executive offices. And there's never a perfect balance in that. But what this bill's trying to do, I think, is, and for good or bad, whatever we do, we pass statutes, and then we delegate tremendous authority to different agencies to promulgate rules and regulations in furtherance of that. And those rules and regulations seem to stay forever, and they grow. And so the foundational intent of this bill is simply to provide additional review support to the agencies, and I think ultimately probably to Sunset as well, to try to take a look at those. And as Mr. Borderland testified, it's hard for the agencies every 4 years to really give a time-attentive analysis of all their rules, particularly when they have volumes of them. And Sunset only meets every 12 years as a general rule. And so the idea was to simply set up another office who could be doing independent reviews of bills proposed and enacted, and make those reviews available to the particular agency that was responsible for promulgation of that rule. Now, back to what the bill actually does. It provides that review process, and it is set up to be through the governor's office. He is the chief executive officer over executive agencies for the state, and so he needs to have a regular and routine and substantial oversight role within those agencies. Again, we have delegated that legislative authority to those agencies to create rules, and when we do that, somebody needs to be monitoring that all the time, and we're not here all the time. So the intent was to provide a support office to the agencies in reviewing those regulations. The second part of it that we really haven't talked much about, but I can tell you as a lawyer, I remember clients that they can't even begin to figure out where to look for all their trucking company. They're a contractor. They can't even begin to figure out where to look for all the different rules that govern them. And some of those rules actually don't just have civil penalties, but they have criminal penalties attached to them, fines and other remedies that can be enacted by criminal courts. And so the portal aspect of this bill directs that a central portal be created. And if you're a plumber, or you thinking about being a plumber, or you're a roofer, or you're a trucker, or you're in some chemical distribution business, that you've got a central place that you can go to on that website. You can type in those keywords, and that portal will pull up every regulation that governs your business. And not only will that help you be a better business and a better citizen, but it'll help keep you out of trouble too. And there's nothing like that available in Texas today. So the portal aspect was the second part of this bill. And the Chevron aspect, so many of our businesses, banking, trucking, you can go on and on, so many of our businesses have had federal and state rules promulgated by agencies that govern them. Banks are a great example because you have state charters and federal charters, but even the state charters are under federal regulation. And so the standards for how they're reviewed, how those rules are reviewed, right now there's ambiguity to that. With the Chevron rule, we know what the standard is for review of a regulation governing a Texas business. But if it's in a state court, we really don't know what that standard of review is. And I would suggest that the standard for reviewing the state regulation needs to be the same standard that's used for the federal regulation, because otherwise not only do you have a federal and state compliance issue that you're trying to interpret and apply, or maybe even enforce, but you would have two different standards for how those are even applied, how they're assessed by a court, and how they're reviewed by a court, what the standard is. And so the third part of this was simply to basically statutorily apply the Chevron to state law as well, so that businesses in Texas will have the same standard of review, whether they're dealing with a federal regulation or a state regulation. And I will tell you, a lot of times in court, you're actually dealing with both of them, even if it's just in a state court. Those federal regulations affect how the state regulations are applied, and they're interwoven. So we need a simple, consistent standard of review. So that's the three things we're trying to do. Simply set up an office to advise state agencies and assist them in the 4-year review process. Create that portal that'll be a great benefit to all businesses and prospective businesses in Texas, including someone who's thinking of moving to Texas. They want to come here from New Jersey. Hey, is the regulation really better or worse in Texas? Well, let me look, and I can go to their portal and find out. And the third piece of that is trying to provide regulatory consistency and certainty for our Texas businesses. That said, I close. But I would ask that we would.
I think I was remiss for asking if there was any other public testimony before I pass that off to you. Hearing none, and this is on for or against Senate Bill 14. Hearing none, public testimony is now closed.
One question.
Oh, yes, sir.
Yeah, Senator King, Chairman, the fiscal impact, this portal that's being.
Yeah, thank you for bringing that back up. I meant to mention that.
That can be IT things are expensive. We've all been on budget writing, but I don't see that actually in here as far as a delineated cost of this. Just the cost being associated only with
that,
35.5.
That was one of the ambiguities I referred to, and we've all had fiscal notes come back somewhat routinely, in fact, that surprise us, and a lot of times that's our fault as authors for not clearly communicating with LBB, and that may in fact be the fault here. I don't know. It may be that the agency that's involved, that there's confusion there, but I think we've all experienced fiscal notes that really surprised us. One of the things in this was, well, how much is the FTEs and how much is for the portal? And the portal, they told us, is actually a very small part of that. I'm a little bit surprised in that. I would have expected the portal to be fairly expensive because it is a first-time setup. It'll be a setup cost. So each one of you have had difficulty and surprises with fiscal notes. What I would ask is please trust me with this one. I'm hoping we can vote this out today because time kills bills. I'm hoping we can move it forward. And I promise you, we have already opened discussions with LBB and with the governor's office, and those are already very friendly and fast-moving discussions. And I believe we'll come back with a fiscal note that everybody will be very comfortable with.
Thank you, Senator. I do see on that the web portal being for easily access all state regulations and laws that apply to specific businesses or business plans. That's a significant endeavor, I would think, from an IT perspective, but I appreciate and respect and trust your input there.
It probably sounds larger than it is because all of those rules and regs are already digital. And so it's a matter of combining them into a new database with a search engine and search capabilities where someone can type in the keywords plumber or whatever it may be, and then those pull up in an accessible and understandable format. But all the regs and everything are already digitized, of course. It's just a matter of compiling them in the new portal. But it should cost some money, and we'll figure out for sure what that is. If the chair would entertain a motion, I would move that we vote this out today.
Okay, Senator King moves that Senate Bill 14 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Senator Sparks,
Aye.
Senator Alvarado,
Abstain.
Senator Johnson, Senator Schwartner,
Aye.
Senator King.
Aye.
3 ayes, 2 abstain.
There being 3 ayes and 2 present, Senate Bill 14 will be reported to the full Senate with favorable recommendation.
Members, thank you. I know that was a long bill to go through, and I appreciate the witnesses and especially appreciate the senators' time and also their confidence in me to get this worked out so we can move it forward. Is there any other business to come before the committee?